That's fantastic walk-up music. It feels very Star Wars. So, Marnix, let's start with you. I'd like to give each of the panelists a minute to introduce themselves, talk a little bit about their practice, and then we'll get into some of the specifics. So, Marnix, why don't you kick it off?
Thank you, Troy. My name is Marnix Leijten. I'm a lawyer based in Amsterdam, a partner at De Brauw. I have been actually practicing law and litigation for 30 years, for a couple of years at Cravath in New York. And my practice is very broadly both arbitration and mass litigation in a broad field, including big tech.
Great. Thank you. Suyen?
Hi, everybody. So I'm Suyen. I'm a partner who heads the international arbitration practice of Wong Partnership. It's a Singapore law firm. It's headquartered in Singapore. We have offices across in China, ASEAN, Middle East. And for my practice as a senior counsel, I have a very active counsel practice before the Singapore courts, including the Singapore International Commercial Courts. I'm admitted to the Royal of England and Wales, and also before the DIFC courts. A large part of my practice, in addition to my court litigation, is in international arbitration. Very delighted to be here.
Great. Thanks, Suyen. And Jamie?
Hi, everybody. I'm Jamie Levy. I'm the Senior Advisor to the Abu Dhabi Investment Office, formerly the General Counsel of the Abu Dhabi Investment Office, an M&A and private equity lawyer by background. Was also the General Counsel of Badla for many years across aerospace, defence, ICT, healthcare and other areas. And I sit on the board of the UAE Australia Business Council also, so have a vantage point on international trade between the UAE and Australia, where we just celebrated the signing of a SEPA under the leadership of the Ministry of Economy. Thank you very much for the invitation today to participate in the panel, and thanks for teeing it up so violently, I think, Troy, when you'd said they're in the crosshairs and it's a tech attack, so looking forward to it.
Well, great. Thank you all. And Jamie, why don't we start with you? I finished up the master talk by previewing kind of this multifaceted attack on big tech and emerging tech, the litigation side, the regulatory side, and then how that's impacting, in your space, investor decisions, the money that's coming in. I'd love to get, and I'm sure the audience would love to hear a little bit about what you're seeing on your side of the world as a non-litigator, how pricing is working, how your clients and your partners are thinking about this multifaceted attack on tech.
Sure. And as you eloquently set out, it is a complex area which provides massive opportunity for litigation financing and claims that was articulated. It provides huge uncertainty in relation to those of us who are both using products, who are investors, who are advising regulators, who are in the C-suite of these big tech companies themselves. I think if you're an investor, a regulator, a consumer, at the moment in this particular area, you've got questions. You know, if you're a parent, and I'm sure there might be a few parents by the look of the audience, who also has questions on their mind about, big tech and safety. It's a confluence of many issues that we see, and I don't think at the moment we have a lot of answers, but we know there's a lot of opportunity here as well. Just last night and this morning, I guess you would have also seen the NVIDIA antitrust-related announcements made. So I don't think it's necessarily just a matter of the crosshairs of big tech focusing themselves and their defences on class actions. It's regulators, it's governments, it's investors that are all going to put pressure into this area on big tech, and it'll be interesting to see the response. We're seeing big tech investors have the queries you mentioned, and perhaps we'll talk about some of those later in the panel, but we're seeing big tech too need to change. When they see regulations in Australia, for example, released around limitations on age access of 16 to social media platforms. I was at the dinner table with my children just recently talking about this, and my 16-year-old daughter just told me it's great for those who are going to be caught by it, but I'm 67 on Facebook. And so the way in which you actually implement and see these regulations implemented is going to be a challenge. So as a parent, I thought to myself there, that's great, I think we've solved this one for the younger kids for a while, and now I realise they're older than me on their Facebook accounts. So implementation, I think, is going to be quite an issue as well. The antitrust point that we mentioned, I think you've got regulators around the world that are going to be putting a lot of pressure on deal closings. So we'll talk about investment, but investment being subject to big CPs that result in potential elongated processes, potential regulator avaricious attitudes that are going to be, I think, more prevalent, are going to create a little bit more uncertainty. And so investors, as you say, when we invest into big tech, may be looking to rep and warranty insurance, maybe looking to some products and services that we'll see evolve in the M&A space, which will be quite fascinating to see. But would agree they're in the crosshairs, and would agree then that for those who are in the litigation financing space, with a hugely growing pool of capital, somewhere between $10 and $20 billion, rising 10 to 30% a year, chasing after not just the most deep-pocketed area of the economy, which is always a great target for a litigation financing strategy, but a strategy that now seems to have had a little bit of certainty put into it by, as you mentioned, those 30 attorney generals that themselves are paving the way for and identifying with big red flags those companies that they themselves will be seeking action against. And so it's an interesting time for both the financiers who are going to find great profitable opportunities for tech, and then for those of us here in Abu Dhabi attracting the leading tech companies like the Abu Dhabi Investment Office. We promote, we attract, we facilitate, and we do so with big tech. Every big tech company on the planet's either here or in great discussions with us, and we know that proactive regulation, and we know that the environment here, the very business-friendly environment, results in them wanting to be here, and we know that with the regulators here are also quite collaborative. So this also is a great opportunity for Abu Dhabi to make a contribution to the global conversation.
Well, that's great. I know a lot of us are going to be watching how Australia's under 16 legislation, which has gotten ahead of most countries in the world, is implemented. There's a lot of skepticism among the lawyers as to enforcement, but it does show how politicized the issue has become as well, and you're now going to have countries and states and other federal authorities getting ahead on the legislative front of the law, while the tech on a minute-by-minute basis continues to evolve and the legislation takes longer to catch up. As we talk about catching up, maybe Marnix, maybe we'll start with you. I spoke a lot about the US litigation hotbed and where things have started. Maybe you could talk about the matriculation of big tech and emerging tech, class action and collective action litigation in Europe and the UK, and then Sui Yan will talk about a much more limited set of litigation in Asia.
Yeah, thanks, Troy. I mean, it's famous. It's a famous saying that if I want to speak to Europe, who am I calling? I'll try to be the other person at the end of the line, although I know my limitations in this respect. I think it's quite important, as far as Europe is concerned, to realize that collective litigation is a new phenomenon, relatively new across the board, and it's been rising very, very quickly. I'd like to distinguish between the UK and continental Europe. In the UK, it has risen off of the Competition Appeals Tribunal, which deals generally with competition issues. And there are at present basically over £30 billion in big cases pending against big tech. There are a number of limitations in the UK to that, because outside of the competition area it's not really possible, so a number of these cases are sort of forced into the competition angle. Even in the UK, I would say generally, we have not seen yet any of these cases coming to big verdicts. And that tells you a lot. I mean, there are many, many procedural hurdles that are being discovered, and also substantive hurdles to these big claims. If I just give you an example, which is not straight from the big tech area, but there's been a very famous case pending between Merrick and MasterCard, which is the biggest in England, representing all users of MasterCard, which is a 20 billion case. 2 weeks ago, there was an announcement mid-trial that was going to be settled, that 20 billion case, which had been pending for 9 years, for 200 million. And now that has led to a very public spat between the funder and essentially the client who thinks it's a good idea. It's not really clear why that's being settled for that amount. One can assume that a very, very large part of that amount has actually already been spent in litigation costs, it being very expensive to litigate in the UK. But there's clarity that there's reason for the claimant to go from 200 million to 20. I think there's a general similarity there with the continent. The continent has been a place where litigation was very far away from what the landscape looked like in the United States. The European continent used to be not very litigious at all. Basically, tradition was not so much to litigate, but to resolve things amicably. That changed. If I go 15 years back, we used to look in horror at the US, at all these class actions and very large settlements and verdicts. That was something that there was universal consensus about in continental Europe that we didn't want. It used to be frowned upon as something that got completely out of control. That's where we were 15 years ago. Now that has completely changed, particularly in two jurisdictions. One is the Netherlands, where I'm from, and the other is Portugal. Those are the only jurisdictions in Europe at this point in time that have opt-out class actions, which means that you can start a case on behalf of a class and everyone is caught unless you opt out. That's a big advantage. A lot of the other jurisdictions have opt-in class actions, and that's much harder to set up. What has happened is phenomenal. In the Netherlands, basically, it's become a total magnet for class actions. There are many, many pending against big tech. All the big tech companies you know have big cases. And something changed. And I think it's very important to realize there, if I look at it, and that goes across the whole spectrum. It's not only big tech, it's climate litigation, a case against Shell that you may have heard about, that maybe the next panel will talk about, and other types of industries where one can say legislatures have either not been able to keep up with developments, which is mostly in big tech, or as a matter of political disagreement, legislators have not been able to actually produce helpful legislation to make it clear to companies what is expected of them. That creates a problem. And that creates a problem, a vacuum, that is being filled by very large class actions, both against the government, but also against corporations. Why is that a problem? It is a problem because of the separation of powers. We see that as a big issue. The predictability of these cases is very low, and that's not the fault of the judiciary. But once the legislature and the executive don't succeed in creating a legislative and regulatory environment that is predictable, people are going to go to courts, and courts have to take decisions that they would rather not take, that fall straight into essentially unpredictability and political polarization. That is a big issue. There are many big ones pending at the moment. I'll give you one example just to give a feeling for this. In 2020, a case was started against TikTok in the Netherlands for 6 billion in damages. What's the case theory? The case theory is about privacy, which obviously in EU is a big topic given GDPR legislation, which is fairly detailed but also not detailed enough to really be predictable as to what it would mean for a company like TikTok. And it's also related to addiction. Now, what does it claim? It claims for every user of TikTok in the Netherlands, Netherlands is a small country, there are 4.5 million in 2020. It claims essentially emotional distress damage because of these violation of privacy and the violations of essentially the addictive effect of it. And that adds up to 6 billion. Now, my children, who are teenagers, actually love this litigation. They love TikTok, but they wouldn't object to actually getting 1,500 euros in compensation for their emotional distress. This case has been pending for 3 years now and has not crossed the procedural hurdles of admissibility of the foundations that started it and class certification. It's going to be pending for a long time because no one really knows, either substantively or procedurally, how to deal with it. It's a very interesting phenomenon, I think, in Europe. There's a similar activity now upcoming in Portugal, which has been later to the game in terms of opt-out class actions. But we have dozens of them for a very small country, very unusual, and is very threatening for companies, but also, as I said, for the politicization of the judiciary.
That's very comprehensive, thank you. Suyen, we had talked about much more limited scope in Asia, but interested in your take and kind of what you see coming down the pike, if not now, over the next 5 to 7 years. What are the possibilities for the Asian market and for attacks on tech in the litigation context in your hemisphere?
Well, thanks, Troy, very much for that question. Well, it is a very big question when we talk about big tech, because Asia, as everyone knows, is a very big continent. So when we look across the landscape as to, has the US playbook on class actions and against the big tech, has that really found its way in Asia? And if we scan across some of the key jurisdictions like China, India, South Korea, Singapore as one of the key financial hubs and where a lot of the litigation take place, you have not seen that growth as much, but you already see the start of such litigation. One of the reasons that I would say it has taken a much slower pace in Asia is, again, I'm making this a very generalized statement. As I said, Asia consists of many different countries, a very large continent. But there's a general perception of it being a less litigious society. So even if we take a look from Singapore, we don't have this concept of a class action. The best that we have is a representative action. And representative action, how that's different from a class action, is representative action is an opt-in, which means that you need the consent of each of the plaintiffs. You then have a represented class, and you can then represent thousands, hundreds, depending on what consent you have. So because of that, in fact, what the Court of Appeal in the 2013 case, which I argued before the Court of Appeal, they said the criteria is not difficult to satisfy as a representative action. You need to have a common interest and then a common grievance. But the problem with getting that is that precisely because it is opt-in, there is always that difficulty in securing the consent across the various plaintiffs' groups. So in China, you likewise have this opt-in action. When you come to South Korea, I think one of the most interesting space to watch, as you know, South Korea is very, is in a sense really at the forefront when it comes to technology and has very big companies there, is that a lot of the class action talk and the possibility of class action have arisen from, like what Jamie mentioned, regulatory authorities' action. So how you see this class action evolving is, first, the regulatory authorities actually imposes sort of fines on, for instance, in Korea, I think it's a company called Naver, and it's a search engine, which is a platform which gives the search and tells the consumer which is the entity to go to purchase this particular product. It's the same way that Google does its algorithm. But the algorithm is meant and deemed to be anti-competitive because it pushes itself as the shopping platform and the go-to shopping place. And as a result of that, it was found guilty of anti-competitive practices. And now what's come from that is a class action from consumer riding on the decision of the regulatory authority to then say, I've suffered loss and damage as a result of this. And I can see this evolving and this being done in the same way in India. Again, there was a cyber hack against a crypto exchange, and the individuals then suffered from it, and the Indian authorities found it guilty for not taking enough steps to prevent the cyber hack. And as a result of that, the consumer then riding on the decision of the regulatory authority then went on to start their class action. So this is a trend that I see, and you will see more of this in Asia.
You know, Jamie, you've worn a lot of hats, including a general counsel hat at one point. And you think about emerging tech as opposed to big tech, which is well established, has hierarchy. You think of emerging tech where the legal advice that these companies are seeking from their in-house counsel and their outside counsel is, what are our risks in connection with our evolving technology? At the same time, they're facing data privacy issues, hacking and ransomware issues, things that are affecting not just big tech and emerging tech, but other companies as well. When you think about the general counsel perspective, what are the types of issues, both on the acquisition investment, but also the investment in R&D and the like? What are the type of things that you would have been counseling your clients on as they look at this very litigious landscape for some unknown period of time?
Thanks very much, Troy. I think it would be a longer conversation with most of the executive now than it would have been perhaps 10 years ago, particularly when we look at the acquisition cycle, we would see a fairly binary approach to, if we're going to buy into a company, what are your current claims against you? Let's try to size the prize of what that might look like by way of a liability and price that in somehow, and perhaps we come back to some of the W&I insurance products or other mitigants, indemnities, etc. But we can size it. But as Marnix just very articulately outlined there, some of these claims are going to outlive a reasonable investment period for closing a deal. And so I think going into a deal now, you're going to have to consider that a feature of the transaction involves potential reputational overhang for a lengthy period of time, ongoing regulator interaction, and perhaps fine and related penalty discussions, and that you may not be able to price your full liability in. So I think the uncertainty there requires emerging tech and investors to actually turn to governance. And we look at the ESG implications for how emerging tech needs to look and feel to institutional investors. It's sophisticated from a governance perspective. It's understanding that safety is primarily the most important piece of the consumer experience, whether that's safety in relation to data, whether it's safety in relation to the addictive nature of gaming and certain sites and certain big tech products. And I think that's where, again, an Abu Dhabi perspective here is that safety is a very important piece. So for those of you in the room who were at the Mubadala Forum on Saturday, it was the primary subject of the generative AI discussion. It wasn't necessarily about let's as investors focus on regulator action, preempts, and trying to work through deal mechanics. It was about let's ensure the products, the companies, and the approach in Abu Dhabi has a safety-first approach. And if you look at MGX, for example, a $100 billion fund, that will invest into many emerging tech opportunities as well as data centers and generative AI. The entities around it, whether it's G42, Core 42, for those who know these entities pre-site and inception, the artificial intelligence regime here is going to be governed and overseen by something called the Advanced Technology Research Centre, which exists now and is doing a wonderful job in overseeing this to support investors to understand what does the regulator think. So I think for us here in Abu Dhabi, we have an advanced manner in which both regulators and capital is coming together to support investment into emerging tech companies, but to also ensure that investments that are being made here have that safety first respect. And so as a general counsel or former general counsel, I'd be advising the M&A team and advising the investment committee that gone are the days of thinking, like the tobacco industry, for example, that these particular class actions are going to be one and done, or that we can settle this and move forward in a manner that was perhaps a little bit more certain. I think we have to understand that even with responsible forward thinking and future-proofing governance, you're still, as a big tech and emerging tech company, traversing a very uncertain and dangerous environment from the litigation perspective. You could be world leading, but still be, as we've said, in the crosshairs of litigation financing, who see the deep pockets of the sector as being absolutely worth a continued and long-term shot at. So consider yourself under fire, and the best strategy for when you're under fire is to future-proof. So they're going to need to get ahead of themselves. And if you're the general counsel of one of these entities, ESG, data privacy, and your ongoing proactive collaboration with your head of audit, your head of risk, your operational risk people, you're going to find much closer collaborations there to try to identify where's the bump in the night coming, how could our industry be and ourselves be subject to a large claim, what would that do to our business? And you probably find that your relationships with leading law firms and your funding requirements, where as a general counsel asking for a legal budget is always a bit of a difficult ask, kind of like asking for Christmas presents after Christmas. No one really wants to say yes to you. But these CEOs really acknowledge now that part of progressing my business and having that innovation mindset that they need to have, this kind of break something, move fast attitude that existed 10 years ago, and perhaps even some entities now, will have a very strong legal governance oversight over it as well, in order to ensure that break something and move fast doesn't cause unsafe products in the hands of consumers, with the 30 or so attorney generals in the US identifying what a great company for us to start going after, and the litigation financing entities seeing profit in keeping these companies perhaps honest. And I think that last piece is also an important reflection on what it is that these claims are going to do to some of the companies. It really means you have to be thinking through a scenario where you assume it's coming, and you are becoming not you're preserving your innovation, but you're doing so in a manner that allows you to be on the front foot with regulators, have a very solid documentation trail as to how you innovate, what you've done, what your testing regime was like, how you monitor any potential damage, and what mitigation actions you take. But that probably means larger risk compliance legal functions within what is perhaps not naturally thought about in the context of such innovative companies which produce products which change our lives and which we all rely on.
Jumping off of the point which I previewed and you made earlier on litigation funding, and the fact that litigation funding, like water, will fill any crack, any void in the industry, and because of the sheer number of potential litigation matters across the globe going after big tech and emerging tech. Marnix, it will be interesting to hear kind of the European UK perspective. Obviously in the UK, a lot of litigation funding, collective action funding where possible. What are you seeing in your region from the standpoint of the funders driving the agenda of copycatting the attack on big and emerging tech in the US to kind of matriculate it west, starting with UK and Europe?
Yeah, I think that the short answer is that playbook is exactly the same. There's an enormous amount of funding available, not only in the UK, but a lot of the UK funders are very focused as well on continental Europe, as I said, not because I'm from the Netherlands, but basically also in the Netherlands. You can find it everywhere. And funders drive this agenda to a very large extent. Interestingly, one needs to realize as well that there are basically purely commercial funders, but there's also a lot of funding for public interest type litigation, climate type litigation. So there are huge amounts of money available. And as a general matter, I think litigation funding can be a good thing because it creates access to justice. I think there too, there's a bit of a problem, at least in continental Europe, that there's no proper regulation around, disclosing interests and basically behavior and the influence of funders on the strategy of the case versus the interest of the client. But it's plentifully available, and it's clearly one of the very significant driving forces against the cases, and particularly the non-commercial funders also drive, let's say, a even more politicized type of strategy, which in a way is good, but also is worrying around the separation of powers and the pressure that sets on democracy.
It's interesting. in the US, there has been a recent, in the last few years, pushback by some courts on litigation funding and litigation funding disclosure. And the reason that many courts have started to require mandatory disclosures of funders is because of patent infringement and patent troll litigation, the potential chilling effect on innovation and making it more costly to innovate within not just tech, manufacturing and chemical as well, but there has been this pushback. So hearing that there is this tension in the US where the litigation funding market is enormous, new money coming into play, cost of capital being what it is, you want to get that money to work as soon as possible, and you're looking for the next opportunity. The reaction to the litigation funding market, to some of the disclosure rules in the patent space, are likely going to find their new crevices in big tech litigation and some of these big addiction and related litigations. Suyann, I'm going to ask you an unfair question, which none of us can really answer, but I think you're best situated. Looking ahead 7 to 10 years, as the litigation against big and emerging tech continues to emerge, generative AI becomes more and more in the crosshairs with data privacy concerns, loss of autonomy, protection, and safe applications, as Jamie was speaking about. What do you see generally, it doesn't have to just be in the Asian legal market, what do you see generally as maybe the next frontier of litigation against big tech and emerging tech?
Well, Troy, you mentioned generative AI, and I think for generative AI, one of the biggest issues that they face is that it is as good as the data that is fed within it. So when you look at the fact that the generative AI really builds on the data that is given, and then from that produces a product, the natural question, and it has already been litigated in many courts, in many of the Chinese courts, the internet courts in China, it's also been litigated in India, also in South Korea. The question is there any copyright infringement? So the copyright infringement claims against big generative AI companies is there, and that is definitely going to grow. We just recently had a most recent India litigation where one of the biggest news agency went after ChatGPT. We went after them for the very fact that all the data that's crawled is actually from the news agency, and the question is there any copyright infringement? And all these cases are ongoing. So I think things which are linked to this aspect of copyright infringement is definitely going to be there. The next aspect, which I think is really big, and it goes to the point that Jamie mentioned about safety first, and the kind of litigation that can be brought about by the consumer as a result of the harm they have suffered due to the lack of the tech giant to practice responsibly and to ensure that its practices are safe. So you have already seen, for instance, various actions that's been brought about by consumers who themselves, as a result of the lack of protection and the lack of security and monitoring that's been administered by the big tech, that they then go on to start action where they say they themselves have been the subject of harm, whether they've been subject of bullying that has not been actually nipped in the bud. There has been the Rohingya refugees have started action against Meta to say that because of the way that they did not clamp down on the hate speech against them, that they've created this entire environment where they are being persecuted globally, because Meta just didn't do enough to stop some of these untrue stories going on Facebook. So all this action in the various jurisdictions is going to come about. And the question for really the consumer and the big tech is, where would this litigation take place? I think that is really the big question and the very exciting question. One would naturally assume US, because of the US class action regime, because of the fact that all the big tech are based there, and this is where they think they'll get the advantage, and the US would feel, there's a certain system that makes it very plaintiff friendly to a certain extent. But the question then becomes, would it just be simply a US action? Would it be more of where the harm is suffered, where the consumers are based? Would there be anti-suit injunctions being taken out to prevent certain litigation from ongoing? We already see that with the browse rep agreements, the arbitration agreements, where where parties would take out to prevent a class action from continuing due to the existence of an arbitration agreement, which is a very low threshold to meet. As long as there's a prima facie arbitration agreement, you grant a stay. So increasingly, you will see all these cross-border disputes where we are talking about jurisdictional fight. We're talking about where's the best place for the litigation, anti-suit injunctions, and that then requires very, very good, I think, collaboration across various business units and across various law firms who are very strong in their domestic jurisdictional practice to see what's the best way to navigate all these issues.
Yeah, you know, that's interesting. I also think what we see in the U.S. as kind of the potential next frontier, and this is fed a little bit by what maybe some of you in the room have seen concerning news coverage of the last 2 election cycles. And for the incoming president, Trump's second term in January, one of the next battlegrounds, which while it'll be fought in the court of public opinion with respect to the treatment of the media and social media platforms, what I think plaintiffs' lawyers and some of the existing litigations will seize on is this potentially artificial dichotomy between content moderation, which for the last 10 years has been seen as a non-controversial topic, something that you would expect social media platforms to put in place. In fact, when there wasn't adequate content moderation, that was a basis to attack and file suit. Now, there's been kind of this morphing of content moderation into this idea of censorship. Is content moderation on social media platforms censorship? And if so, is that actionable? And will the federal government in the U.S. have a regulatory attack on social media platforms and media platforms? Because content moderation, a relatively non-controversial topic 10 years ago, has become a new battleground. And does that shift quickly in 4 or 5 years when the next administration? And does it matriculate west? Are there issues that are copycat in the UK and Europe and into the Middle East and Asia? So I think that is another battleground that we're going to see emerge here. How it influences the current litigation dynamic in the US is a bit unknown, but it is definitely already being previewed. In fact, President-elect Trump's pick for the Federal Communications Commission, the FCC, that regulates communications, including on social media platforms, was well known prior to his selection for being a social media platform is censorship advocate, and has stated in a lot of publications that his first frontier against big tech in the social media space will be just that, will be attacking content moderation versus censorship. And it may be a way around some of the First Amendment immunity that big tech social media has the protection of within the United States. So stay tuned for that. It'll be potentially a different discussion at Resolve 2025. Before we leave in the minutes we have, I wanted to give each of you a chance to kind of give some final thoughts. And since we're in your hometown, Jamie, why don't you kick us off?
Look, I think when we opened up the session, we realised that there's just a huge set of subjects here, from monitoring of big tech, implementation of their solutions within all of the consumers, particularly children and those who are the subject of what we were originally discussing, really, which is those vulnerable need to be protected. We all have a degree and a view of what that protection looks like. We all want regulators to act proactively, and we say that, but when we see the laws and we see the regulations, and we then think about implementation, whether it's the Australian example I gave you and how easy it seems for the youth to simply bypass it if they want to access social media platforms. It seems that the old adage of the tech being just ahead of regulation and law will just continue. And so it's the room here with regulators, with court administrators, with lawyers and advisors who are going to be the people that will need to step up and try to work through how will this regulation come to be to actually serve the other big topic we talked about, which is safety, to ensure that those consuming these products are going to do so safely. We know that big tech's not going away, nor do I think we want them to go away. Each of you have a phone that if you leave on your seat and go out to the bathroom, you'll be petrified as soon as you leave the room, that someone's got your phone, and that you don't have access to your social media or your messaging systems. We can't live without it. And so it's not really going to be a matter, I think, of very harsh regulation, but regulation that facilitates use responsibly is going to be the battleground, and that's going to be where we've seen, with President-elect and also he's the head of Department of Government Spend and others with pretty strong views on the subject. I think it's a different issue I'd like to put on the table is the environment, and this is energy. The energy required to power the generative AI impact of the future is staggering, and the impact that will have on the environment, on the use of energy, on the application of energy, on the mix of energy in an economy. Here in Abu Dhabi, we have nuclear, as well as renewables, as well as the oil and gas sector. So we have quite a comprehensive energy mix and approach. But there are countries that want to play in this space where the actual query for them is, do you have the energy capacity and the social license to be able to apply energy toward that? So another topic, and perhaps that's your climate topic next. But I think it's a fascinating space. We'll continue to see litigation financiers run after this space because of the deep pockets and because of the vulnerabilities they present. This is an industry which has thrived on getting product to market first and figuring out the consequences later. And that will continue to fuel, I think, legal, regulatory, and other stakeholders here to be stapled to and handcuffed to big tech as it progresses.
Well, I feel like your comments there have validated Morgan Lewis's development of a data center working group and all of the legal and litigation and regulatory issues concerning the generation of power for AI. So thank you for that. I'll let our chair know. Suyen, final comments?
I'll pick my final comment from what you just said about censorship. Well, Singapore actually took a very robust approach when we were looking at the falsehoods that's being perpetrated on the internet, and we look at the many false statements that's made and what this has led to some societal harm, where some teenagers felt certain, and it caused personal harm. So as a result of that, actually, we passed a Protection from Online Falsehood and Manipulation Act in Singapore, which essentially gives the court the jurisdiction to issue stop orders against, platforms, against like Meta, against Instagram, any Twitter, any platform, X, they call it now, yeah, but any platform, if there was this view that there was an online falsehood and it was manipulation. So when we passed this act, we had many conversations with the big tech. They were all up in arms against Singapore. They said, this is freedom of speech. How could you put this censorship on us? How could you just simply assert jurisdiction just because the internet is accessible in Singapore? We had a long conversation with them before we managed to streamline the entire act, but we decided to go ahead despite their protests. The one little caveat we gave them was that they said we still need to satisfy service outside jurisdiction on them, which is their respective and where they are based, which is not difficult. And I think this is very interesting as to whether other jurisdictions, if we really talk about safety first, and we really talk about tech companies having this social responsibility, would they take this step like Singapore did to actually pass an act which may sound to many, what an intrusion.
Great. Marnix, the last 70 seconds are yours.
Yeah, I think two things. I think what you see in Europe and its effective life, that we're now seeing a lot of litigation in the class action sphere that pit fundamental rights against each other. Whether it is in the climate space, it's right to life, as the ACHR has said, versus the primary need for energy and the fact of life that not all energy is renewable. Now, how to resolve that in a particular situation, in a particular litigation, is beyond 70 seconds and beyond me. And the same is true for big tech litigation, where you have the right to privacy versus freedom of speech. We're sort of there in a very highly polarized environment, and also geopolitically there's a polarized environment, which in my view will lead to far more litigation around this to sort of try and prevail As for companies making acquisitions or looking at litigations, my view is that basically it's no longer the answer to try and predict what a judge will find in a couple of years, what the outcome will be. That's, it's pretentious to think that you can predict that. It's far more important to look at how to mitigate the consequences and the risks, what you can adapt to your product, to your services, to basically try and figure out how to mitigate and engage with all the stakeholders internally and outside to figure out what the best course forward is, rather than managing the litigation that used to be the case.
Great. Thank you. Well, self-interestedly, it'll keep us all employed for the next 10 years. Thank you for your time.